Hey everyone, my name is Altagracia Pierre Outerbridge. I am a landlord-tenant attorney located in New York City in Midtown Manhattan. My firm is Outerbridge Law PC, and I am here today to speak to you about an issue that has been on everyone's mind. It has been discussed, it has been debated, it has been written about, and importantly, we have received a lot of calls about it, which is today's March 31st, and tomorrow is April 1st. Do I have to pay the rent, and what are the consequences of me not paying the rent as a tenant in New York City? So addressing the first question, there is right now in effect an eviction moratorium by the governor of the state of New York, which goes through June 20, 2020. So through June 2020, evictions cannot occur. City marshals have been ordered to not carry out any eviction until at least through June 2020. So it may be that this moratorium is renewed. If not, at least through June 2020, no evictions can occur. So what happens after June 2020? So going back, landlords are not, the housing courts are closed except for emergency applications. So landlords, and a non-payment of rent is not an emergency application. So landlords are not able to commence any cases that are not emergencies, and non-payment of rent is not an emergency in housing court. So landlords cannot even commence a non-payment proceeding. So going to the question of, do I have to pay my rent? The first part of that is, it's a tiered answer. The first part of the answer is, look at your lease. Your lease controls your tenancy. Most leases provide for payment of rent by the first of the month, which is tomorrow. There has been no suspension of cancellation of rent, so rent is due on the first of the month. Some leases provide for a grace period by which time you are able, sometimes usually 5 days, by which you are able to pay the rent with or without a late fee. So what happens after that time? What happens if you don't pay the rent? So again, we talked about the moratorium on evictions and the fact that housing courts are closed. And what happens after June 2020 if you don't pay the rent? So tenants should know that the process of eviction does not occur without process itself. So you cannot be evicted unless it's done illegally through an illegal lockout or some other way, harassment or another method, which is not permitted by law. You cannot be evicted without the landlord commencing a case and obtaining a judgment and warrant against you. So you're not going to be able to lose your home unless the landlord does it properly, right? So in order for a landlord to get a judgment and a warrant, that process is rather lengthy, and it's also very, very procedural. And that procedure also serves as a series of pitfalls for the landlord to abide by before you can lose your home. So talk about how long the process is. The first step of the process is a 5-day service by certified mail of a 5-day notice of non-receipt of rent. Thereafter, or simultaneously, the landlord has to serve you with a 14-day notice by regular service. That means somebody has to hand it to you, right? Usually that's a process server. After that 14 days, the landlord then has to go to court and obtain and file a petition and notice of petition. After the landlord files this, right? So we're already talking about 19-20 days already. If the landlord does this rather expeditiously, the landlord, after those 19-20 days, the landlord goes to housing court and files a petition and notice of petition. The landlord, after being served with that petition and notice of petition, in service of that takes some time too, right? I've seen it take 3 to 5 days to get a petition served, because the law provides for proper service of the petition or of petition, and that usually includes two attempts, unless they actually find you, the tenant of record, and serve you personally. So this is all to say that also takes time. After that time period, after you're served with the petition, and please keep track of how you were served, because that is a defense to a non-payment proceeding as well, whether or not you were served properly. After that time, right? After you are served with the petition notice of petition, you are then afforded 10 days to answer the petition, and obtain a court date. So please do not ignore if you receive any court papers, do not ignore them, right? So you should be receiving a postcard, right, as well as a petition and notice of petition. Upon receiving that, you have 10 days to answer. Upon answering, the court has to set a date, and there's also a time period thereafter that the court has to set a date. It's no less than 3 days, no more than 8 days after you answer that the court sets a date. Upon you answering, you have the right. So when you go to the housing court or hire an attorney to draft your answer, you have the right to state any defense that you have against this payment of rent, whether it be lack of repairs, right? Any defense that you think you're entitled to, you should put in your answer, right? Because that will become relevant. Thereafter, after the 10 days you've answered, the court sets the date to be no more than 8 days, right? You're afforded at least one adjournment when you go to housing court, when you actually appear in housing court, be that to get an attorney or for any other reason. That's usually no less than 14 days. So we're talking about a good time period wherein you are aware of the proceeding and you're able to hopefully come up with the rent or come up with an understanding with the landlord, right? After that, the only way that the landlord gets a judgment and a warrant is by either you agreeing to it, right? Agreeing in writing in what we call the stipulation, a court document that you sign, that the court orders, that the court makes into an order. It's a stipulation that you sign that you agree to the judgment and the warrant, or there has to be a trial. As you can imagine, a trial takes time to actually get to. So this is all to say that there's a good amount of time built between you receiving the first notice that the landlord means to commence a non-pay, which is a 5-day notice of non-receipt, and the actual final, which is having a judgment and a warrant and having a marshal execute on that warrant, right? So even after you agree or the court issues a judgment and warrant, right, against you, you still have the opportunity to come back to court and, obviously at the discretion of the court, seek more time to pay, right? Talk about the hardship that you've endured and why you deserve more time to pay and what steps you're taking to come up with the money. So there are many protections set up for New York City tenants to make sure that an eviction process not only is rather procedural, but also takes a good amount of time for the tenant to be able to protect their home. So even after the judgment and warrant, you are able to seek more time from the court or from the other side. And even up until, right, the expiration of the 14-day warrant, you're able to pay and stop any eviction. That wasn't the case before. Once the warrant issued, you had trouble stopping it, even by paying. At this point, even with a warrant, you're paying the rent before the marshal comes, does restore your tenancy. So I hope I was able to provide some comfort, some answers as to what happens if you don't pay the rent tomorrow, April 1st. Should you pay the rent, and what happens if you don't? So again, there are a lot of protections built in for New York City tenants. Feel free to reach out to us if you have any need once everything settles or beforehand. Nevertheless, of course, this issue can get a bit more complicated. A review of your lease is necessary to find whether the defenses you may have as a commercial or residential tenant to pay the rent. But the short answer is what we just, if it could be short answers, is what we just discussed. Again, a review of your lease may reveal some other defenses to this, to payment of rent. We suggest you speak to an attorney, and we're here to service you should you wish to call us. Our firm is Outerbridge Law PC, and our number is 212-364-5612. Thank you, and good luck.